Pam Bondi, standing alone in the storm against a system built to silence her. What you're about to hear isn't theory, it's truth, wrapped in courage, defiance, and quiet strength. So lean in, because this story will challenge what you think you know about power, justice, and the cost of speaking up. The fluorescent lights of Courtroom 7C in the Orange County Courthouse cast a pale, sterile glow over everything. Wood-paneled walls, a row of tight-lipped attorneys, and a judge who looked like he hadn't blinked in 20 minutes. Pam Bondi stood alone at the defendant's table, her posture as calm and deliberate as ever, dressed in a navy suit that whispered experience more than flash. The room was unusually quiet, not the kind of respectful quiet born from procedure, but the kind forged from tension. On the bench, Judge Malcolm Rayner leaned slightly forward and read from the statement in front of him without emotion. This court finds you in contempt for making extrajudicial statements that undermine the integrity of a sealed civil matter. You are hereby fined $50,000, payable in full within 30 days. His voice was flat, almost mechanical, like a sentence he'd read 100 times before. Pam didn't blink. She didn't flinch. Instead, she responded in a tone steady as stone. "Understood, Your Honor." But what came next wasn't in the script. With measured calm, she reached into the soft leather case beside her chair, pulled out a plain manila folder, and laid it gently on the table. There was nothing flashy about it, no tabs jutting out, no dramatic labels, just 3 red marks along the top edge. Still, the shift in the room was instant. The air itself seemed to draw inward. Every experienced professional in that courtroom knew what a move like that could mean, and they'd all heard the rumors. In the weeks leading up to this hearing, murmurs had circulated in tight legal circles about a whistleblower, a vanished deposition, and a sealed case involving Central Florida Mercy Hospital that had been quietly buried. Pam had made a brief radio appearance 2 weeks prior, where she hadn't named names, but she'd said enough for those familiar with the system to connect the dots, enough for Judge Rayner to issue a gag order, and now, this fine. Rayner raised an eyebrow, his voice low but edged. "Ms. Bondi, do you have something you wish to submit to the court?" She didn't hesitate. "I do," she said, her tone even, "but only if this court is willing to hear it in full context." That word, context, hung in the air like a loaded question. For the first time all morning the judge faltered. He glanced toward his clerk, then back at Pam, then at the folder. The weight of silence in the room became crushing. "You may proceed," he said. Slowly, carefully, Pam opened the folder. The first sheet was an internal email flagged "Privileged, do not share," dated 4 months earlier. The second, a sworn statement. And the third, most damning, a printed version of a court filing that didn't match the one in official records. She laid them out one by one with surgical precision. "What I've brought today," she said, "is not opinion. These are documented facts that raise serious questions about the handling of a civil complaint involving preventable harm, judicial bias, and the removal of material evidence." Judge Rayner sat motionless, his fingers steepled in front of him. He didn't object. He didn't strike it from the record. He simply said, "This will be reviewed," and moved on. Pam knew what that meant. A stall, a delay, a warning shot, but it was too late for warnings, because what she'd just done was more than present a file. She'd thrown down a challenge, not just to a man in a robe, but to the system that protected him. And for the first time, the silence wasn't just tense, it was scared. 6 months earlier, Pam Bondi had no intention of stepping back into the legal spotlight. Her mornings were quiet, deliberately so. Sunrises over St. Augustine's Matanzas Bay, a ceramic mug of black coffee in one hand, and no deadlines in sight. After years in the trenches of Florida's most high-profile legal battles, she had traded urgency for stillness. Until her phone rang at 6:47 a.m. The number wasn't saved, but the voice on the other end was unmistakable. Nina Torres, once a driven legal aide in the state attorney's office, now a freelance journalist scraping stories together between part-time gigs. They hadn't spoken in years. "Pam," Nina said without preamble, her voice tight, almost breathless, I need you to listen to something." Before Pam could respond, a recording began to play. It was scratchy, recorded secondhand but clear enough. Two voices, a man and a woman, arguing. "I told you, it's not in the file anymore." He pulled it. Then a pause. "Then you didn't hear it from me." The call ended before Pam could ask a single question. She stared at the phone for a long time. That clipped exchange hadn't just sounded suspicious, it had sounded familiar, the kind of backroom panic that happens when something damning gets buried. 20 minutes later, Pam called Nina back. "Where did this come from?" she asked. Nina hesitated. "You don't want to know, not yet." By noon, Pam was on the road. She drove west, windows down, salt wind in her hair, all the way to Ocala, where Nina lived in a modest A-frame near the edge of the forest. They met in the kitchen, phones turned off, blinds drawn. Nina pulled out a weathered envelope stuffed with photocopies and printouts. On the front, scribbled in black ink, was a single name, Cameron Ellis, a physician, a name Pam vaguely recognized. "He filed a civil complaint last year," Nina explained, "against Central Florida Mercy Hospital. The case settled quietly, but this," she tapped the file, "this isn't the complaint that went to court." Pam sat down and began reading. The paperwork was disjointed but alarming. Original intake forms, internal incident reports, and handwritten notes from the ER the night a teenage patient named Maya Torres died from what appeared to be preventable negligence. What caught Pam's attention most was the structure of the original complaint compared to the version entered into court records. Pages were missing. Sections had been reworded. Key names, senior hospital staff were nowhere to be found. "It's like they wiped it," Nina said quietly. The case they ruled on wasn't the one he filed. Pam leaned back, her eyes scanning the ceiling, trying to locate the gut feeling she hadn't felt in years. The one that told her when something wasn't just wrong, it was rigged. She flipped to the last page of the file. The presiding judge's name was printed clearly across the header, Malcolm Rayner, and in that moment her pulse slowed. "He's not just another judge," Pam murmured. "He plays long." Nina looked at her. "You think he buried it?" Pam didn't answer, not directly. She just said two words that shifted the air in the room. "I'm digging." Pam found Dr. Cameron Ellis exactly where Nina said he'd be, tucked into a corner booth at a nearly empty diner just off University Avenue in Gainesville, nursing a black coffee like it was a shield. He looked exhausted, older than his 38 years, his white coat long replaced with a gray hoodie, and anxious eyes. "You really came?" he said when she slid into the seat across from him. Pam nodded. "You asked for someone who wouldn't look away." He didn't smile, but something in his posture eased. For the next hour, the physician told her everything about Maya Torres, the 14-year-old girl who came into the ER seizing, alone and scared. "She needed constant monitoring," Cameron said, voice tight. "I told the charge nurse, twice, but someone somewhere decided to move staff, left her unattended for 10 minutes. That was all it took. Maya died before the on-call neurologist made it to her bedside. And then, according to Cameron, the hospital scrambled, not to investigate, but to cover." He had filed a formal report immediately, but by the time the hospital's internal review wrapped up, that report had been reframed as inconclusive, and two administrators who'd approved the staffing change were left out of the final summary entirely. That's when he filed suit, not out of vengeance, he said, but out of principle. Her mother deserved to know the truth, that it wasn't just tragic, it was preventable. The original complaint named names, it cited timelines, internal memos, even text messages between ER supervisors, but when the court hearing arrived, something felt off. Cameron said the tone of the defense shifted, from evasive to oddly confident, like they already knew what would and wouldn't be discussed. Then came the settlement offer, quiet, generous, but loaded with restrictions. He wasn't allowed to speak to media, not allowed to publish or comment publicly. "They told me it was the best I could hope for." Cameron didn't want to take the money, but after pressure from hospital attorneys and his own lawyer warning him he was outgunned, he agreed. Barely. What he didn't expect was to later discover that the final court record didn't match the document he had filed. "I kept a copy. I know I wasn't supposed to, but I had to." He slid a worn file folder across the table to Pam, and as she opened it, her breath caught. Whole pages were different, witnesses omitted. An entire section detailing the ER staffing chain of command was gone. "They made it look clean," she murmured, "like it was never messy to begin with." Cameron nodded. "They didn't just scrub the story, they rewrote it." The worst part, though, wasn't the redactions. It was a single internal memo Pam found buried in the stack. It was unsigned, but its language was clinical and unmistakable. Recommend early suppression strategy prior to hearing. Identify liability vectors and pursue pre-adjudication containment. The date? 1 day before Cameron's original complaint was even officially received by the court. Pam looked up at him. "They planned this!" Cameron didn't respond. He didn't have to. Everything about his expression said he'd known. But seeing someone else read it made it real all over again. Pam closed the folder carefully, like sealing a wound. "They buried the truth before it had a chance to breathe," she said, and she knew then, this case wasn't a one-off. It was the first tile in a mosaic of rot. Pam didn't stop at Cameron's case. If what he alleged was true and every instinct in her said it was, then this wasn't a single act of judicial negligence, it was systemic. So she began combing through the public records of Judge Malcolm Rayner's recent dockets, focusing on civil suits involving large institutions, hospitals, banks, insurance companies. The deeper she dug, the more disturbing the pattern became. There were 3 other cases that echoed the same structure. Critical evidence introduced early on, then quietly removed or dismissed. Plaintiffs who had originally filed with detailed complaints, only for their final court versions to look sanitized, vague, or oddly truncated. In one instance, a wrongful termination lawsuit, filed by a whistleblower against a pharmaceutical giant, had originally included internal emails showing knowledge of faulty lab results. Those emails were never mentioned during trial. The case was sealed and settled in mediation within weeks. Another case, this one a class action suit against a retirement facility for elder abuse, showed signs of tampering so blatant it made Pam pause. Timestamps on filed motions had been altered, minutes shaved and resubmitted without new signatures. At first glance it looked like clerical errors, but once is a mistake, repeated across 3 cases, it was a blueprint. What made it all the more chilling was the consistency of players. In each instance, the same 2 law firms kept appearing, either as defense counsel or co-counsel for the institutional defendants. And while different associates handled the briefs, the lead strategists were always the same: Darren Lowe, a litigation consultant based in Tallahassee, and Celeste Marin, a partner at a boutique corporate defense firm with long-standing ties to Judge Rayner. Pam mapped it all out on a wall in her home office, threading names, case numbers, rulings, and settlements with colored tape, like she was solving a conspiracy theory. But this wasn't theory. It was case law, it was court transcripts, it was real. And the connections weren't just legal, they were personal. Rayner had once co-chaired a private judicial retreat sponsored by Marin's firm. Lowe's name appeared in donor records tied to a political action committee Judge Rayner had supported during his reappointment campaign. Pam wasn't surprised, but she was angry, because every string she pulled unraveled another layer of quiet manipulation, all buried under the appearance of judicial order. More disturbing was the fact that these altered outcomes didn't just shield institutions, they silenced victims. Plaintiffs walked away confused, discouraged, often feeling like their own story had been rewritten in front of them. It wasn't enough to deny justice. The system was erasing the very notion of what had happened. Pam stood back from her board late one night, eyes scanning the lines and intersections. "This isn't just negligence," she murmured. "It's architecture." She took a breath and wrote one name in red ink across the center of it all: Rayner. Not just a judge, but a gatekeeper. One who decided what truth made it into the record, and what vanished before the public ever got the chance to see. Her wall of evidence was growing, but what Pam needed next wasn't just documents. It was a voice from inside the machine. That breakthrough came in the form of a hesitant text message sent late one evening from an unlisted number. The message was simple. If you're serious, I have something, but this conversation doesn't happen on record. The sender was Eliza Monroe, a former court clerk who had served under Judge Rayner for 4 years. 3 of them during the very cases Pam had flagged. Pam arranged to meet her in the quiet back booth of a bookstore cafe in Mount Dora, far from courthouses, media, and anyone watching. Eliza arrived wearing oversized sunglasses, her posture stiff, cautious. "I shouldn't be doing this, but I can't unsee what I saw." They talked for over an hour, and the picture that emerged was even worse than Pam expected. Eliza confirmed what Pam had suspected. Judge Rayner often received case summaries, strategic outlines, before those cases were even assigned to his docket. These summaries weren't coming from the official court system but from a private legal consultancy, almost certainly Darren Lowe's outfit. He'd get them delivered in sealed envelopes, Eliza said, and he'd read them alone before our team even prepped the intake files. She also detailed instances where Rayner instructed her, personally, to remove or revise deposition exhibits before they were filed. He'd use phrases like unnecessary duplication or non-essential language, she said. But the content was always material, always something that would complicate the optics of a ruling. The most damning revelation came when Eliza slid a small USB drive across the table. "I copied a handful of internal memos during my last month. I wasn't supposed to. I was scared. But I couldn't pretend anymore." Pam reviewed the contents later that night. What she found confirmed not only that Judge Rayner was shaping legal outcomes, but that he was coordinating with outside counsel to do so in advance. One memo, dated just days before Cameron Ellis filed his complaint, read, "Early filtration advised, redline high-risk exhibits, request suppression authority through ex parte if necessary." Another, unsigned but time-stamped during a holiday recess, detailed a preferred narrative timeline for a wrongful death suit and recommended it be streamlined to avoid trial exposure. Eliza's affidavit, which she agreed to provide anonymously at first, outlined 2 occasions where court filings were reworded before being uploaded to the record, and a third where a plaintiff's supplemental exhibit simply vanished. "It never made it into the docket," she said. "Rayner said it was misplaced, but I saw it, I scanned it." Pam knew what she had wasn't just compelling, it was explosive. But it also came with risk. Eliza had walked away from the court quietly a year ago, no exit interview, no formal complaint. "If this goes public," she said, "I lose everything, my job, my bar admission path, my safety." Pam reached across the table. "I won't use your name unless you say I can." "But Eliza..." "This can't keep happening." Eliza nodded, tears threatening but never falling. "Just promise me something. Don't let them bury this one too." Pam didn't hesitate. "I won't." And she meant it. Because now she wasn't just building a case, she was protecting the people brave enough to tell the truth inside it. Pam had barely begun organizing Eliza's affidavit and the internal memos when the backlash started. It didn't come with sirens or subpoenas. It came in silence, the kind of silence that feels strategic. Within days, speaking engagements Pam had booked months in advance were postponed indefinitely. A scheduled keynote at Florida Coastal Law School disappeared from their website without explanation. Her inbox, once buzzing with media requests and consulting referrals, went quiet. At first, she tried to chalk it up to coincidence, but then came the call. From her longtime accountant, a man who'd managed her finances since her time in office. His voice was polite but nervous. "Pam, I'm just going to say this once. You might want to take a step back from anything public. You're making people uneasy." She asked him directly, "What people?" He didn't answer. He didn't have to. She hung up and sat in her kitchen, the walls closing in around her, but her resolve hardening. Then came the smear. A mid-level political blog ran a vague hit piece implying Pam was on a personal crusade for relevance, painting her as a bitter former official clinging to fading notoriety. The quotes were unattributed, the sources anonymous, but the fingerprints were familiar. Classic reputation discrediting. A day later, a journalist from a regional paper in Tallahassee reached out for comment. "They're saying you're trying to unearth old ghosts, that you've got an axe to grind." Pam paused. "Did they mention the Ellis case?" The reporter hesitated. "No, just general stuff, nothing specific," she sighed. "Then maybe ask yourself why they didn't." Within a week, she received notice of a court summons, a contempt hearing for allegedly violating the original gag order. The timing was surgical. She was given 2 business days to appear. No specific citation of what she'd said or how she'd interfered, just a line stating her remarks threatened the integrity of an ongoing matter. She wasn't surprised. This was classic procedural retaliation. The message was clear. You keep talking, we'll keep tightening the screws. She considered bringing a lawyer, but ultimately decided against it. If they wanted to make an example out of her, she would face them directly, without filters. Even in the courthouse, she felt the shift. Security didn't greet her by name like they used to. A few colleagues she recognized avoided eye contact entirely. When she tried to speak briefly to a former colleague who had worked on one of the altered cases, he gave her a half-hearted shrug and said, "I've got a family to feed, Pam." She wasn't asking him to go public, just to confirm what she already knew. "Doesn't matter," he muttered, eyes darting. "People talk." And that was the point. The fear wasn't abstract, it was engineered. That night, Pam sat alone in her home office, the lights low, reviewing the manila folder that had become her anchor. Inside it now were 3 affidavits, timelines, and redacted memos. She was being punished for saying too much, but it was clear that silence was what they truly demanded, and for Pam that was no longer an option. The morning of the hearing, the Orlando sky hung heavy and gray, rain gently tapping against Pam Bondi's windshield. She sat alone in her car, the same leather case by her side that had followed her into capital trials years ago. Inside it, a 3-page motion she'd written in the middle of the night, and the thick manila folder filled with everything they didn't want seen. No entourage, no private entrance. She walked through the front doors, on purpose. Let them see her coming. Courtroom 7C was half full. Reporters, law students, a few attorneys watching with blank faces. Judge Malcolm Rayner sat on the bench, flanked by 2 bailiffs and a clerk. In the second row sat his wife, Frances, expressionless but unmistakably present. Whether it was support or intimidation, Pam couldn't tell. The hearing was called to order at 10 a.m. sharp. She rose when her name was called, not with bravado but with calm purpose. "Your Honor," she began, "I'm not here to dispute the court's authority. I'm here to challenge the narrative that I've undermined it." She opened the folder and laid down 3 documents: a sworn affidavit from Eliza Monroe, a memo referencing suppression strategy before a case was filed, and a side-by-side comparison of Dr. Cameron Ellis's original complaint and what the court ultimately processed. "These are not opinions," Pam continued. "They are certified, time-stamped, and they show inconsistencies, evidence of coordination between private consultants and this bench." A quiet unease swept the room. No one spoke, but tension buzzed in the air. A reporter's pen scratched faster. An assistant state attorney leaned forward. Judge Rayner didn't react, except for the slight tightening of his grip on the pen in his hand. "Miss Bondi," he said slowly, "what exactly is your motion?" Pam answered without hesitation. "A judicial review of the Ellis case by an independent panel and a temporary stay of the contempt fine until that review is complete." After a pause, Rayner finally turned to the clerk. "File the motion. A written response will be issued within 7 business days." Pam nodded. "Thank you, Your Honor." She returned to her seat, but the calm on her face belied what she knew. This was a stall. They were hoping she'd walk away. As the hearing ended, reporters swarmed. One young journalist asked, "Was that really a sworn statement from someone inside the judge's chambers?" Pam zipped the folder shut and met his eyes. "It was real. That's all I'll say for now." Then she stepped out into the rain, not victorious, but unshaken. The game was still on, and next time it wouldn't be played behind closed doors. Pam didn't wait for Judge Rayner's written response. 2 days after the hearing, she agreed to an interview since the contempt charge. The conversation began cautiously. Legal boundaries still mattered. But when the reporter leaned forward and asked, "Are you afraid of retaliation?" Pam didn't even blink. "No," she said flatly. "I've already been punished. The only thing they can do now is prove me right or prove me wrong." That line made the front page the next morning, printed beneath a photo of her walking into the courthouse with the folder under her arm. It didn't go viral, but it spread fast enough. A retired judge in California shared it on social media, writing, "If even half of what she's alleging is true, this demands urgent review." A legal ethics podcast host from Austin reached out for an interview. Quietly, Pam's story began to drift out of Florida's grasp. 3 days later, it finally happened. The Florida Judicial Qualifications Commission, JQC, released a brief but unmistakable statement. They were launching an internal review into Judge Rayner's recent case history. No timeline, no elaboration, just an acknowledgement that enough concern had been raised to warrant attention. Pam read the announcement on her porch, the ocean breeze lifting the corners of the newspaper in her lap, and she didn't smile, she didn't celebrate. Instead, she picked up her phone and sent a 2-word text to Eliza. They blinked. And that was the shift. It wasn't explosive, there were no sirens or press conferences, but something had cracked. People who had been too afraid to speak were now peeking around corners. One former legal intern forwarded her a redacted memo with the initials MRR. Another sent an email, "If Eliza is finally talking, maybe it's safe for the rest of us." Pam didn't respond right away. She just opened her folder, added the new pages to the growing stack, and exhaled. For months she'd been alone in the storm, shouting into a system that refused to listen. But now there was an echo. The headlines didn't last. Within 2 weeks the media moved on. Gubernatorial races, hurricane warnings, celebrity scandals. That's how it always went, but Pam wasn't chasing headlines. She was watching for cracks. And they were still widening. In her home office in St. Augustine, the manila folder sat in plain view, growing thicker with each passing week. New pieces of the puzzle arrived quietly, redacted memos, unsigned notes, small corrections from people who remembered what wasn't in the record. But the moment that stayed with her most came not from a leak, but a plain envelope with no return address. Inside was a handwritten note. "I was one of the jurors in the Ellis case. We never saw the full file. I remember wondering why. Thank you for not letting it slide." No name. Just that. Pam folded the note and placed it beside the folder. There was no parade, no resignation from Judge Rayner, at least not yet. But the Judicial Qualifications Commission investigation was active, and eyes that once looked away were now paying closer attention. The media attention had faded, but Pam felt the shift. She resumed quiet consulting, no lawsuits, no cameras, just the steady rhythm of law. Some mornings she still checked the court docket for new filings in Rayner's courtroom. Old habits. One afternoon, while walking along the beach, the tide pulling at her ankles, her phone rang. It was Nina Torres. "You saw the update?" she asked. "They're assigning a panel from out of state." Pam paused. "Good. That's how it should have been from the start." Then came the question, how did you keep going when everything told you to stop? Pam looked out at the water. Because if I let it go, that meant I agreed with it, and I couldn't live with that. No spotlight, no grand finale, just a quiet decision to stand when every comfort begged her to sit down. Because sometimes, the only victory that matters is refusing to be silent when silence is what they demand. The story of Pam Bondi's stand against judicial corruption isn't just about law, it's about integrity in the face of silence. The lesson is clear. When institutions meant to uphold justice begin protecting themselves instead, it takes courage to challenge the system from within. Pam didn't have a team or a platform. What she had was the truth, and the resolve not to look away. Despite the pressure to stay quiet, the threats to her reputation, and the manufactured silence that surrounded her, she chose to speak. This story reminds us that change rarely starts with power. It starts with one person refusing to let wrong become routine. Pam's decision to stand, even when it cost her comfort, exposed not just one corrupt judge, but a pattern designed to erase accountability. And it wasn't grand gestures that made the impact, it was documentation, persistence, and quiet bravery. In a world where many choose the safe route, this story teaches that real integrity means standing firm when the easy choice is to disappear. Because silence may protect you in the moment, but truth, spoken at the right time, can shake even the strongest walls. Let me know if you'd like a quote or excerpt graphic version for social sharing.